All right, good afternoon. Good afternoon. I'm Kevin Vance. I'm the director of the Center for Constitutional Liberty here at Benedictine College. And the mission of the center is to renew an understanding of America's founding principles and bring them to a new generation. And today we're having the college's Constitution Day lecture. And I also wanted to thank the Jack Miller Center for their support for this event. Our next event will be on November 1st. Nicholas Nikas will give a talk on the post-Dobbs landscape. And I'd like to introduce our student fellow who will introduce our speaker. Jeff Schremer is from Pittsburgh, Kansas. He's a sophomore who majors in political science and economics. He's a Gregorian Fellow, a Constitutional Fellow, and he is the Student Body Vice President. And he's also a recent recipient of the Transforming Culture in America Award. So I'd like to welcome Jeff to come introduce our speaker.
Yuval Levin is the Director of Social, Cultural, and Constitutional Studies at the American Enterprise Institute, where he also holds the Beth and Ravenel Curry Chair in Public Policy. The founder and editor of National Affairs, he is also a senior editor at The New Atlantis, a contributing editor at National Review, and a contributing opinion writer at The New York Times. At AEI, Dr. Levin and scholars at the Social, Cultural, and Constitutional Studies Research Division study the foundations of self-government and the future of law, regulation, and constitutionalism. They also explore the state of American social, political, and civic life, focusing on the preconditions necessary for family, community, and country to flourish. Dr. Levin served as a member of the White House Domestic Policy Staff under President George W. Bush. He was also executive director of the President's Council on Bioethics and a congressional staffer at the member, committee, and leadership levels. In addition to being interviewed frequently on radio and television, Levin has published essays and articles in numerous publications, including The Wall Street Journal, The Atlantic, and Commentary. He is the author of several books on political theory and public policy, most recently, A Time to Build, From Family and Community to Congress and the Campus, How Recommitting to Our Institutions Can Revive the American Dream. He holds an MA and PhD from the Committee on Social Thought at the University of Chicago. Please welcome Dr. Yuval Levin.
Thank you very much. I appreciate that introduction enormously, and I appreciate the invitation to be with you. It's always wonderful to get a little flavor of a campus community, and I have to tell you that the sense I've gotten from just a short time here today is a sense of an extraordinary community. We had Professor Vance and I had lunch with a wonderful group of students this afternoon that just left me enormously impressed. And I laugh a little bit because to say Professor Vance is slightly funny to me. Kevin Vance used to work for me when he was a couple years out of college. And I really wish that meant that I had some embarrassing stories about him to share with you, but I don't. And it's actually kind of hard to imagine embarrassing stories about him. So maybe there just simply aren't any. I'm very grateful for the chance to speak with you, particularly because you have here a center that thinks about the nature of constitutionalism in connection with the kind of work that the larger university does toward the formation of the human person and liberal education. And I think that this is really a time to be thinking about constitutionalism in that context, and to be thinking about it in the context of a society that could really use some help hanging together and understanding what it is that unites it and holds it together. And so what I want to talk about today really is the question of the Constitution and national unity and how those two relate to each other. We're obviously living in a moment of intense division in American public life, and oftentimes it seems like our constitutional system only makes the bitter conflicts that we're living through more intense and worse for a variety of reasons. The constitutional system can be slow and cumbersome. It's filled with restraints. It's filled with all kinds of veto points that can make the majority in our politics at any given time feel like its will is being denied and democracy is failing. At the same time, the system is democratic, and so in key respects it is majoritarian, which often makes minorities in our politics, whether they're religious or racial or ideological or cultural minorities, feel endangered and unprotected. And the key institutions of our system at this point, especially the three core institutions, Congress and the presidency and the courts, often seem increasingly like venues for divisive partisan combat and for a kind of clownish culture war performance art rather than the work they were meant to do. They're places where we display our divisions more often than they are places where we repair our divisions. And all of that can persuade a lot of Americans that the Constitution cannot serve a divided society, that it takes for granted more common ground than we actually have now, and so only ends up making the problems we have worse. And so you find people calling for dismantling the system, or at least for getting rid of those elements of it that depart from simple majority rule, on the premise that a more simply democratic system might be less divisive. I want to suggest to you today that something like the opposite of that is closer to the truth. That in fact, the American Constitution was intended to create and not just to occupy common ground in our society. And that some of its most frustrating features, and maybe especially the ones that restrain majorities sometimes, are among the most essential to that purpose of creating common ground. The Constitution was offered as an answer to just the question that we now often face in America, the question of how a diverse and divided society can hold together and govern itself. The very first ambition that the preamble to the Constitution articulates for itself is to form a more perfect union. And the kind of first person plural in which the document presents itself, beginning with the fact that the very first word of the Constitution is we, is aspirational as much as it is empirical. Our system of government aims to make that we a more durable reality, not just once through its creation, but in an ongoing way through its continuing operation to bring us more closely together. That aim, I think, is even more clear in the structure and the substance of the Constitution. Its institutions, the carefully adjusted balances between them, are intended in part exactly to enable, even to compel Americans to be a little bit more accommodating of one another, a little less frustrated and embittered, a little better formed into citizens who are willing and able to collaborate and compromise and work together to advance the common good. Now, that may sound like a strange way to describe our system of government because it's certainly not how our politics is working now. But that fact itself should lead us to ask some hard questions about our contemporary practice of constitutional government in America, and not just about the underlying structure of the system. Rather than throw out that system or deform it to better suit today's kind of grotesque civic vices, we should look to the logic of the Constitution for some guidance toward constructive institutional reforms and healthier political habits. If we actually want a more unified society, then we should see the Constitution much more as a solution than as a problem, I would say. And let me try to suggest to you why I think so and how that can work. We can start with just a little bit of an overview of the nature of the solution that the Constitution offers to the challenges of how a divided society can govern itself and hold together. The document clearly was framed with a keen awareness of the plurality and the fractiousness of the American nation, which are not new. And the challenge of division is not a new challenge. The Constitution is offered as a way to live with the reality of our diversity and our divisions, not to make that reality go away, which is unrealistic and which we wouldn't really want anyway, but to govern ourselves well in light of it. It seeks, in other words, to enable social peace, which cannot be taken for granted under modern conditions of pluralism. Social peace can offer a kind of stable backdrop for political life. In a free society, it's not quiet, but raucous. It can't be achieved by surrender or by conquest, but only by mutual accommodation. Social peace is something like the condition of differing without rejecting one another's legitimacy, of disputing without being at war. The very idea of a written constitution that stands apart from just regular legislation as the framework of a system of government, the setting rather than the subject of political disputes, is rooted, I think, in the ambition to establish some common ground in a permanently fractious society. By drawing a distinction between views about the system of government and views about policies or interests, it stakes out some space for agreement that can allow our disagreements to be dealt with more constructively. In this sense, it's built on the understanding that our political culture, even in times of relative peace and quiet, is by its nature a culture of disagreement. That's a very important point to understand. The cultural breakdown that we're living through now in American political life is not a function of our having forgotten how to agree with each other. It's a function of our having forgotten how to disagree with each other in a constructive way. And that is what our Constitution can better enable us to do. In fact, even before it establishes specific institutions or particular modes of political action, our system gestures toward a set of practices, an ethic, I would say, for resolving disputes that we rarely actually articulate or think through in its parts. It offers a few distinct modes of dealing with differences, and those really define its spirit, and ultimately, in a way, the spirit of our society itself. I would point to three of these kinds of distinct modes of dealing with difference that particularly stand out and are important for us to understand now. The first I would call the ethos of competition, which again and again characterizes the Constitution's approach to clashing factions and interests and ambitions. Competition is a kind of core organizing principle of the system. The democratic underpinnings of the legitimacy of our government is the competitive election. Federalism, which over and over manages to kind of spin diversity into vitality, sets communities and governments in a constructive competition with each other. The First Amendment works to sustain a space for competing ideas, competing beliefs, competing practices to coexist and vie for adherence in our society. And the Constitution assumes and supports and regulates a commercial economy in which competition is an engine of prosperity. The Constitution doesn't articulate a formal theory of competition, but rather it presumes and embodies the centrality of competition to the strength of a free society. Competition enables both democracy and efficiency, energy and legitimacy. And in governing, the imperative for competition forces you to face reality. It forces you to change when you fail. It forces you to adapt when you lose, and so to grow stronger exactly by learning from diversity, from different approaches than the one that you have tried. But subjecting rival interests to a kind of test to choose a winner is not the only way to deal with difference or with division in our system. A second, equally crucial mode of turning disagreement into strength alongside competition is something more like the ethos of negotiation. In key moments, our system of government forces differing interests and ambitions to deal with each other, often literally to make deals with each other. Bargaining and accommodation are invaluable tools for resolving disputes peacefully, not so much by determining which side is stronger as by reaching some kind of accord between them. But the American system does not assume that the instinct for bargaining will come naturally to citizens or even to their representatives. Rather, it forces people with differing interests and views to engage with each other by making some kinds of bargaining unavoidable. This sort of prejudice in favor of negotiation can easily be mistaken for another example of the ethic of competition, but they're not the same. The president and Congress, for example, don't really compete with each other. Neither of them can do its work without somehow bargaining and dealing with the other. The two houses of Congress don't put different options before a consumer to see which will be most attractive. They have to negotiate with each other before either of them can accomplish anything. Now, that's true in any representative democracy to some degree, but the American system stands out for making negotiation really unavoidable. It practically never empowers anyone to act alone. Every step has to be achieved by some degree of engagement and buy-in from others. And crucially, even majorities generally have to negotiate with minorities before they can act. That's a frequent source of frustration, obviously, and of accusations that our system is not democratic enough. But our Constitution recognizes that majority rule can sometimes be a principle of despotism, not just of legitimacy. So rather than simple majority rule, it looks to build something more like consensus rule. That's one way in which the Constitution balances the democratic imperative to empower majorities and the liberal imperative to protect minorities. It's precisely a way of manufacturing common ground in society, of producing consensus that otherwise would not have existed. A third important facet of our constitutional ethos may be less familiar, though it combines elements of competition and negotiation. I would call it something like dialectical institutionalism. Let me explain that. It's the instinct that is evident in the design of the system to respond to what seem like stark alternatives, even opposites, by embracing both at the same time. The Constitution does this constantly. So, for example, embracing liberalism and republicanism, individualism and community, majority rule and the protection of minority rights, consolidation.
Things without changing its fundamental character. And it's rooted in a particular way of thinking about politics that looks to countervailing pressures and as counterbalances that enable stability. So it seeks what I describe as a kind of active balance, not stasis, but a way of keeping from falling over in one direction or another by enabling both sides to push and pull all the time. Again, it's not quiet, but it is peace and balance. And that kind of balance is seen as a core goal of political life in our system. That's really one way to conceive of the combination of these three elements of our constitutional character. By embracing conflicting aims together, by compelling political combatants into negotiation, by putting different interests into competition, the system drives us to engage with each other precisely where we disagree.
Through common action, at the very heart of our deepest disputes in American life. That kind of politics of building common ground through common action is one rough definition of the term republicanism, a term that appears a lot in the founding era, but that we've kind of lost touch with a little bit. It's a term that turns out to be really essential to understanding the promise and the demands of the American system. The framers constantly insisted on describing the regime that they framed as a Republican government, lowercase r, Republican government. But we've just about lost the capacity to even grasp what they meant by that term. It's not a concept that's really part of our political vocabulary now, and it's time that we recovered it a little so that we gained a sense of what our system can offer us in a time like this. It's not an easy thing to recover. In a really wonderful recent book, the political scientist Michael Hawley argues that classical republicanism rested on what he describes as three pillars: popular sovereignty, liberty, and natural law. In an important recent paper, the Manhattan Institute's Andy Smerek argues that American republicanism rests on five premises: that citizens are equal and self-governing, that they exhibit civic virtue, take a kind of active ownership of the fate of their community, that democracy is how we make decisions, that public life should advance the common good, and that government should be active but limited. I think these are both useful frameworks for defining republicanism, but mostly they highlight the fact that we don't have a very good definition of republicanism. And it seems to me that that kind of definition would help us deal with a lot of confusions in this moment in our politics. I would argue, for example, that most of the problems that some people on the right now attribute to excesses of liberalism actually are better understood as resulting from a shortage of republicanism. And so that they require not an overthrowing of some element of our political heritage, but a recovery of one that's been nearly lost, a project of restoration rather than of demolition. In any case, the framers plainly wanted to put republicanism at the heart of their project. And among the implications of that fact is that the system aims at a politics of common action and of solidarity achieved by engagement and accommodation, not by hostility and exclusion. And that kind of Republican vision of the common good is evident in the constitutional system not only as this kind of general ethos or a mode of action, but all the more so in the particular institutional arrangements that you find created by the Constitution. So in looking at the institutions of the system, too, you find that they are intended to create and not just to occupy common ground, especially to create it through common action. The first of these institutions is Congress, and not by coincidence. It's Article I, and it's Article I for a reason in the Constitution. In Federalist 51, James Madison says that in Republican government, the legislative authority necessarily predominates. Now, that's not good news for him, at least not exclusively good news. He thinks it can be very inconvenient if you want to balance and divide the powers of government. But that observation for Madison is not just descriptive, it's also prescriptive. It's of the essence of Republican government that the legislature should predominate, because the legislature is the branch of government whose work is fundamentally representative of the people. A government in which the legislature does not predominate is not a Republican government. But the framers' design of the Congress demonstrates, I think, an understanding of another, more profound, less obvious purpose of legislative action in a Republican polity. The legislature matters not only because it's representative, but also because it can be formative of national unity. For one thing, just acting together, even through representatives, to make laws that bind all of us is inherently a kind of unifying practice. The freedom of a society to make laws for itself is an essential priority of Republican government. It's a precondition for the kind of civic unity that it calls for. If you look at the Declaration of Independence, the first 6 grievances against King George III in the second half of the document involve a denial of this communal right to self-government through legislation. They accuse the king of not letting us make our own laws in one way or another. But more importantly, the way that our Congress is meant to work in particular reflects a deep understanding of how to deal with divisive differences constructively. In a society that's already unified, a single individual could well represent the national will, right? If we were not divided, the president could just represent us. And there have always been people in American politics who have thought of that as the president's job. The Constitution does not think of that as the president's job. Rather, it's built on the premise that our society is always going to need to work on unity, so that a lot of the practice of our politics has to involve the building of consensus, the forging of common ground, this kind of incremental construction of solidarity. And that kind of work has to begin with the representation of our plurality, not of our unity. It can only really happen in a plural institution, not in a unitary one. So the Congress is the only really representative institution in our system, and what it represents are our differences. It's constructed as an arena for hashing out those differences. The U.S. Congress is different from the kinds of parliaments that you'd find in most other democracies because it doesn't empower simple majorities to govern unrestrained until they lose their mandate. The distinct and overlapping electorates that choose the House and Senate, the constant threat of presidential vetoes, the various kinds of supermajority requirements, including the filibuster in the Senate, which is not in the Constitution, but I think advances its aims, they all mean that narrow and ephemeral majorities cannot really exercise power effectively in our system. They have to deal with broad and durable minorities. They have to work to build consensus before they can really exercise power. One reason for these kind of complicated checks on majority power is obviously to protect minorities, which is a very important purpose of our system. But another is exactly to build consensus that reaches further than simple majority power, to make us more unified before we act. And just as social peace is not always quiet, so building consensus is not always amicable and friendly. In fact, negotiating processes inherently by their nature are adversarial. But by compelling different factions to deal with each other, with the aim, ultimately, of concrete common action, these sorts of processes can build common ground. An effective legislative accommodation doesn't just give each side half a loaf. It gives us practical experience in living together and acting together and thinking together. It builds cohesion. It builds social capital. By simultaneously representing a diverse population and working out differences in its name, Congress sometimes can reflect its compromises back upon the public and create shared ambitions where before there were only conflicting ambitions. And that kind of bargaining is how our system is ultimately meant to work. Most policy debates do not involve the deepest fundamental questions of American political life. And they also don't involve purely technical questions with precise scientific answers. Rather, they embody disputes between broadly legitimate, if not equally reasonable, options for public action. Finding the right answer in that kind of situation is not a matter of metaphysical proofs. It's not a matter of technocratic formulas. It's a matter of settling on an approach that is most broadly satisfactory to the people involved. There's no one coherent public will for the president to embody. There's no one clear answer for a judge to find. There are differences to be worked out through good faith legislative bargaining. And as much as it is a source of public policy, Congress is a source of that kind of accommodation, an arena for working out differences in ways that can disarm dangerous divisions. A system with a reasonably functional Congress at its center is a system with that kind of accommodation at its center, and so with the desire and the ability to resolve disputes within a shared framework at its center. Now, if you've looked at Congress lately, then you probably don't recognize it in this description. And needless to say, that is not what Congress looks like most of the time at this moment. There have been some instances in the last few years of genuine cross-partisan bargaining over key issues, especially thanks to the filibuster in the Senate. But it's been all too rare, and a lot of the time the institution is dominated by culture war theatrics, by partisan grandstanding. But the real trouble is that when reformers think about how Congress might need to change, they too often overlook what it's actually failing to do. Frustrated with the failure to advance their favorite legislation, rather than with the failure to advance national cohesion, they end up yearning for the model of a more narrowly majoritarian kind of European parliament. But that kind of model is not likely to yield durable legislation in our system. And more important, it would further undermine the capacity of our politics to engage in common work toward common goals. If Congress is to be reformed, it should be made better able to facilitate bargaining across lines of difference, rather than less dependent on that kind of bargaining. And to see that is, I think, one way to see how our system in general, and Congress in particular, could be part of building more solidarity in our society. The second institution of our system, the presidency, is by its nature a unitary institution, so it can't play the same kind of role in advancing national cohesion. It's not a venue for accommodation or bargaining. It's a kind of locus of action that's intended both to execute the laws and just to respond to demanding practical challenges on behalf of the country. But in both of those respects, and along with the other essential duties of the office, the president does have an important role to play in making greater national unity possible. And that, too, I think, is evident in the structure of the presidency as much as in its powers. To see that, we have to recognize that the Constitution establishes a government in which, because of the sheer scope of the republic, effective administration is extremely important, unusually important. The framers put a huge amount of emphasis on this point, and it can be a little hard to understand just why they focus on it so much. James Madison thought that the poor administration of the national government under the Articles of Confederation, before the Constitution, was a threat to public peace, and a key reason why they needed to call the Constitutional Convention in the first place. Alexander Hamilton in Federalist 68 says bluntly a very strange thing. He says, quote, "The true test of a good government is its aptitude and tendency to produce a good administration." Ultimately, you test how good a government is by how well it governs, which on the one hand seems very simple, on the other hand is a very complicated and important idea. Because crucially for them, this meant not only effective and energetic management of public affairs, it does mean that, but maybe above all, for both of them, and for the framers in general who thought most about the presidency, good government in this respect, good administration, meant especially stability in the work of government and in its relation to the people. Stability, or what Hamilton in Federalist 70 calls steady administration, is a precondition to a healthy political culture. And it's necessary not only for good government, but also for the unity of the underlying society. Effective and steady administration can contribute to the lowering of the political temperature, to a sense of confidence that elections will not result in sudden and dramatic changes, and so that the stakes of our political contests are not absolute. Not everything hangs on any one election. The president is subject to the laws, which generally can't change abruptly, and in making his own administrative judgments, he's expected to appreciate the importance of steadiness and of stability. He has a duty to enforce even laws that he disagrees with, even court orders that he opposes. And while he's empowered to propose legislation to Congress and to veto bills, he's not ultimately a representative of the public in legislative work. He's the chief administrator of the government. Social peace and the sense of security that's required to engage openly with other citizens, rather than to approach them as enemies or with fear, depend upon the kind of stability that this kind of administration makes possible, so that the president plays a unique role in assuring public confidence in the Constitution and in the government. And that confidence has to be achieved not so much by governing as the public wishes in any given moment, as by governing well. Although the president is elected, the presidency was not intended to be a fundamentally representative institution. The office is defined by a set of duties, and maybe second only to the president's duty to respond to threats to the country's security are his obligations to execute the laws steadily and reliably, and so to set a course that accounts for the dangers of chaos and lawlessness. And here, too, I think our contemporary constitutional practice has become disconnected some from its intended aims. We now think of the presidency in the same terms in which we think of Congress, which are neither legislative terms nor quite executive terms. There's something more like performative partisan terms. And we have particularly lost sight of the importance of steadiness and stability in the work of the president. A change of party in the White House now leads to a nasty case of whiplash. A new president rushes to undo his predecessor's most important signature executive actions and to put in place new temporary measures of his own, which the next president from the opposite party is surely going to get rid of on day one. And the huge apparatus of agencies that's built up around the president, what's come to be called the administrative state, also too often functions as a kind of substitute legislature, less slow and cumbersome than Congress, but not less partisan, a sort of parliament of lawyers that's eager to fill through vigorous administrative rulemaking various kinds of policy voids that the Constitution really intends only incremental legislative accommodation to be filling. And that obviously undermines the work of steady administration, but it's at least as dangerous to our society's capacity for unity, for civic peace. It vastly increases the stakes of presidential elections, and it encourages us to see our society as two opposing camps arrayed against each other for control of the instruments of power. Reigning in the administrative state is therefore not just a matter of constraining government power. It would offer us a way to recover the capacity of our governing institutions to forge some common ground that we lack, and the capacity of the presidency to establish a secure, stable backdrop for American public life, and
just apply texts. And there's
law is inherently vague, and the life of a society in the real world is inherently concrete and particular. James Madison put this point very well. In Federalist 37, he writes, quote, "All new laws, though penned with the greatest technical skill and passed on the fullest and most mature deliberation, are considered as more or less obscure and equivocal until their meaning be liquidated and ascertained by a series of particular discussions and adjudications." Some of that kind of liquidation, as he calls it, takes place through the work of administration, of carrying out the laws, though whether the courts should defer to how executive agencies understand the laws they work under is actually a complicated question. But some of that work has to be done by judges themselves. The question of what sorts of theories of interpretation those judges should be using in determining the meaning of the law is therefore a hugely important question and a very intensely contested question in our country. There's always a danger of judges just reading the laws and the Constitution to say whatever they'd like them to say, to arrive at whatever conclusion the judge would prefer to see in a particular circumstance. And in response to that, a kind of judicial conservatism has proposed originalism, which is an interpretive technique that focuses on what the words on the page meant when they were written. Originalism began as a theory of judicial restraint, which would limit the role of the judge's own judgment, and so presented itself as demanding a kind of neutral textual analysis as a way to give judges the fortitude, the strength to stick to the words of the law or the Constitution. But in the really hardest cases, judges may not just face a lack of will to enforce the original meaning of the law or the Constitution, but an actual lack of clarity about what that meaning actually is or what it entails in the particular circumstances that they face. And some principle, some substantive moral good that they assume is inherent in the Constitution has to guide how they answer that question. The tendency of originalists to ignore or dismiss that problem has driven two major waves of conservative criticism of originalism over the last few decades. Both have been rooted in the sense that substantive neutrality is not possible and is not even desirable as a principle of interpretation because it renders the work of judges ultimately morally empty. The first wave, which was identified with Randy Barnett, a professor of law at Georgetown, proposed that individual liberty, rooted especially in a kind of libertarian reading of the Declaration of Independence, should be the substantive interpretive principle that judges use when they're not sure how to read the Constitution. When in doubt, a judge should lean in the direction of individual rights. The second wave, identified with Adrian Vermeule, a professor of law at Harvard, has argued that an ideal of the common good, rooted particularly in the classical and Christian legal traditions, should serve that purpose. So when in doubt, judges should lean toward a kind of natural law ideal of the common good. In practice, these two would point in opposite directions in many particular cases, right? Individual rights and the common good in a particular situation seem like they would point in opposite directions. But they're actually very similar as critiques of modern originalism and as arguments for an assertive and active judiciary. Both of them kind of chafe against the idea that a judge's role is just to make himself scarce, which in hard cases they see as a kind of evasion of responsibility. That critique has very real force, I think, but it may actually ultimately only point toward a stronger argument for originalism, and one that sheds light on the role that a judge can play in the work of building national unity, the idea that we've been tracing here. The notion that genuinely hard cases require some substantive moral principle, an interpretive principle of the Constitution, is certainly persuasive. But the most persuasive candidate, I think, for that role is exactly the republicanism that underlies the constitutional thinking of the framers. In uncertain cases where the original public meaning of the constitutional text is not obvious, judges should avail themselves of the political philosophy that most prominently motivated the authors of the Constitution. And that philosophy is not so much liberal as it is Republican, small r. It's far from neutral with regard to public morality and civic responsibility. It's grounded in an anthropology of human fallenness and human dignity, in a sociology of civic responsibility and communal self-rule, a politics of solidarity and common action. But as a practical matter, a Republican interpretive principle would actually have a lot in common with contemporary originalism, since it would prioritize the work of the legislature as the embodiment of a community's practice of self-rule. over the substantive preferences of a judge or of the president. It would value steady and effective administration. It would grasp the importance of accommodative, consensus-building social peace and of the rule of law. I think that drawing real practical guidance from an orientation to republicanism would require a lot of intellectual work to clarify the meaning of modern republicanism and also of republicanism as the framers understood it. And that would be constructive work for political and legal theorists in the coming years. And should the case for originalism evolve in that direction, it would also clarify the role that the courts can play in advancing the cause of national cohesion and of the forging of common ground through a kind of Republican political and civic practice. In fact, that small r Republican cause can serve as an appealing organizing principle for American constitutional thought more generally. It points toward the shape that a constitutional restoration should take: the reinvigoration of Congress as a genuinely legislative body that enables cross-partisan negotiation, the prioritization of steady administration in the work of the president and the executive branch, an assertive role for courts in requiring the elected branches to step up to their responsibilities, a restoration of meaningful federalism that's rooted in a commitment to communal self-rule and that balances majority will with minority rights, and an emphasis on responsible citizenship, on civic virtue in our engagement with politics as individual citizens. That's what it would mean to pursue a kind of restoration of republicanism to its proper prominence in America's civic vocabulary. And that kind of approach to constitutional restoration could also offer us a lot, not only in terms of political and administrative benefits, but also as a practical path toward greater unity in our divided society. The Constitution was intended to help our fractious society address its divisions. It offers some proven and plausible ways to do that, but we've lost sight of a lot of those ways, and even of the possibility of meaningful national unity. That Americans have come to see themselves as hopelessly divided is, I think, both a cause and an effect of the constitutional crisis that we're living through now. And that kind of hopelessness also demands that we call upon the resources of our political tradition. Too many thoughtful Americans now dismiss that tradition as shallow, as morally hollow, but I think they've mistaken crude caricatures of our political heritage for the real thing, and so they risk denying our society its capacity for recovery. At the heart of our political tradition is an idea of the human being and the citizen that is rooted in the highest traditions of the West, that we're each fallen and imperfect and yet made in a divine image and possessed of equal dignity, that individuals are social creatures meant to live together, that living together requires a commitment to pursue the common good, and that this pursuit in a free and therefore diverse society requires of the citizen some degree of selflessness and accommodation, restraint, deliberation, and service. Putting up with other people is central to the kind of citizenship we need. That ideal should be a starting point of any constitutional restoration. It calls upon not only our institutions or our leaders or elites, but upon every one of us to take on the responsibility of citizenship and to accept the duties that come with the high privilege of calling ourselves Americans. It gives us each something to do, and it gives us all a lot to do together. And we're going to need to take it seriously if we really do mean to preserve the blessings of liberty to ourselves and our posterity. Thank you.